Hello, my name is Rita Amarichinda, and this is hashtag IP series. To my new listeners, thank you so much for joining and listening. Welcome to IP series, where I talk about recent IP cases and development globally. And this could take the form of copyright, trademark, patent, industrial design, trade secrets, and plant varieties. To my returning listeners, thank you guys for always coming back to listen to my podcast. You can listen to hashtag IP series on Spotify. Thankfully, it's in Nigeria. Anchor, Google, and Apple Podcasts. And welcome to episode 6 of IP series. So today, I will be talking about a very interesting topic in case. So stay tuned, guys. So on today's episode, I'll be talking about the types of trademark that can be registered and allowed under the Nigerian Trademark Act. And our case study features two Big Brother Naija ex-housemates, that is T-Boss and Katrina from the last season. And they are fighting over the use of the word boss lady. Can you imagine, guys? So our case study for today, I happened to, come across it when I had posted the Dr. Omotola podcast version of her trademarking her name, and someone was like, okay, take a look at these two ex Big Brother Naija housemates are fighting over the use of the word boss lady. And someone had already done like a Photoshop, or like they matched two pictures together. So shout out to Fortune for drawing my attention to this. And it just got me thinking, like, it's good to see that Nigerians are taking more interest in intellectual property. People are not registering their trademark, because Katrina went as far as trademarking the name boss lady. So I decided to share my thoughts on the type of trademarks that can be registered and allowed under the Nigerian Trademark Act. So this is I'm focusing more on the Nigerian jurisdiction, because as we know, intellectual property is territorial in nature. So on today's episode, I'll be explaining the types of trademark that can be considered when you decide to register a mark in Nigeria. What is the function of a trademark? What are the trademarks that are allowed to be registered under the Nigerian Trademark Act? What rights do you as a trademark owner have? And finally, the powers and function of the trademark register, the person who puts his seal on the certificate and say, yes, your mark is distinctive enough and qualifies to be registered and finally has been registered. So here's a certificate. So yeah, let's get right into it. So if you remember at the beginning, I said a colleague had actually drawn my attention to this case when I posted the Dr. Omotola trademarking her name podcast. So I'm just going to go over the basics, and I think everyone, be it celebrities, entrepreneurs, startups, they need to know the basics of all of these IPs. So for trademark is considered to be like the commercial signature of a manufacturer or a trader, that makes it easy for his goods and services to be identified, and also to be distinguished from the goods and services of another person. Now, keywords that we need to take note of. Keywords. So under section 67 of the Trademark Act, it said it must be used in relation to goods to indicate its origin, must be used in connection to trade, will have the right to use the mark either as a proprietor or a registered user. And as we know, trademark could be in form of a name, a phrase, catchphrase, slogan, device, logo, sign, symbol, a combination of a three-dimensional sign, sound, color, smell, letters, figures, and numerals. Now, the above listed, that's the things I've listed, must meet the requirement of being very distinctive in nature. And according to Section 9 of the Act, a mark that is to be registered must be distinctive in nature, capable, either distinctive or capable of being distinctive in nature. When it comes to ownership of a mark in Nigeria, we apply the first to file principle. That means if I file a name, a slogan, word, anything that is considered to be a trademark before you, I become the owner of that mark. We don't do the first to use. So first to use with me, I started using it before you. I took my time to register. Whereas for first to file, now me file first, now me get up. Apologies. And I'm judging from this case, it would seem like Katrina is the first person to file. So right now, she'll be considered to be the first person and the owner of the word boss lady. So types of mark that can be trademarked in Nigeria will depend on the degree. Okay, let me use simple. So it will depend on how distinctive, how unique your mark is. So types of mark that can be considered to be distinctive are as follows. So the first type of mark we'll be talking about is a fanciful or coined mark. What this means is that it could be something you just came up with. It doesn't even exist as a word. You just created it and formed it. It's not even in the dictionary. And decide to say, okay, let me use this for commercial purpose. Let me use it and do business and make money. And the advantages or characteristics is that they mean nothing. I mean, no one can say, oh, if you hear this word or name now, you can tell me what it means. That's not the case here. It has never even existed until it became registered. Examples would be Etisalat, now Nine Mobile in Nigeria. Haagen-Dazs, one of my favorite ice cream brand. Thanks to whoever introduced me to it. Thanks to my friend. Oh, yeah. Rolex, Adidas, Kodak, Haribo, Gugu. And the disadvantage is that it has the tendency, it can become generic over time. So let's say you've been using the name for like a very long time. So for instance, now in Nigeria, you want to buy nine mobile. Most people know it as Etisalat. So you have to just say, oh, it used to be called Etisalat. Like, oh, is that it? And then you get your credit. Then another form of mark would be a suggestive mark. So this kind of mark will tell the consumers what your product is about, the services you're rendering, by stating one of its feature. So you have examples like kitchen aid. If you're a baker, I'm sure you have like one kitchen aid. Jaguar, a brand of car. Airbus, and I asked the question while I was doing the tweet, like, with the above definition, would you say that boss lady is a suggestive mark? And surprisingly, 25.6 said yes, while 74.4 said no. I mean, let's go over the definition again. A suggestive mark tells you what the brand is about. Okay, so I do agree with those. I said no. Boss lady is not a suggestive. Like, you don't even know. So boss in literal term will mean like an employer or someone that is your superior, lady, female. So it doesn't really tell you what the product's about. So yeah, kudos to those that voted no. Now the advantage of using the suggestive mark is that it makes consumers to be imaginative. They try to wonder what your product is about. So you're doing watch out for boss lady or watch out for Jaguar, and people are like, ooh, what product is it going to release? What is it going to make? What's coming? It's more like when you see all these franchises around and they're trying to move to a new place and they are breaking and rename, everyone's like, oh, I wonder what brand is coming here. So when you just see like similar marks, say the color that are very significant or are affiliated with the brands, you're like, oh yes, it's Chicken Republic that is coming here. Nice. So yeah, it can be considered to be distinctive. I know that's like a very important requirement when it comes to trademark. It doesn't even describe the mark in question, so Boss Lady cannot be a suggestive. So kudos to the 74.4% that voted no. Now the disadvantage is that it doesn't fall like in the ranking for strong and weak mark. It doesn't fall in the category of being a high mark. Some people are also of the opinion that a suggestive mark should not even be considered for legal backing registration. Like, why are you even going as far as registering Jaguar? Why? I mean, why? But that's just people's thoughts. And I asked, do you agree? And 56% said yes. Why 44% said no? Thank you guys. I mean, I think today I'm for the no's. Let's see how we do for the rest of the episode. But I do not agree that suggestive marks should not be registered, because before you sit down and think of calling or naming your brand, you must have put in so much thought into it. I mean, Jaguar is like a very unique thing. You're thinking of the animal. You're like, okay, is it going to have like a farm or a vet store or something? And then you just see, boom, a car. I mean, yeah, I do agree that it should be, registered. So that's it. Another disadvantage is that the suggestive mark can turn out to be famous. That's not supposed to be a bad thing, is it? But some people think it is. There's nothing wrong with a brand being famous. Who doesn't want to be famous? Okay, so moving on, the third form of mark is arbitrary mark. Now, this uses words or names that have no relation with the mark in question. For instance, Virgin Atlantic. When you think of Virgin, you're thinking of a territory that's never been entered. Apple for technology or computers, or then you're thinking Shell, and then you're thinking Dove. When you see Dove, you're like thinking of like skincare and deodorant. Then you have Gap. If you have Gap too, sorry, Sha. But Gap for clothing line. So Shell is a gas distribution subsidiary of an international oil company that's based in Nigeria. Then you have Apple as a technology company, Gap as a clothing company, Dove for hair products, skin and skincare products, and deodorant. I mean, Dove is a good brand. I like the way this soap smells. Yeah. But those are like some examples of an arbitrary mark. Advantages is that it meets the requirements of being distinctive and capable of distinguishing a mark. So yay! It is also very unique. I mean, who would even think that I would name a skincare product or hair product Dove? Dove is a bird, and it doesn't really have any disadvantage. But if you have any, just send me a message, guys. Another form of mark is a generic mark. Now this is a bit tricky because the mark starts out being very unique, and then over time becomes like the go-to word for product or service that's used to describe the product or services. So for instance, now you can't trademark hair to be used for salon because hair salon, everyone already can connect the dots. Phone for a telecommunication business. However, there's some names or words that have become very generic in Nigeria. For instance, I want to buy Omo. I won't go buy Omo. Do you have Omo? Omo is a brand. but the person literally wants like a detergent and is asking, telling, oh, I want woman. Then when you bring, it's like, no, I want wow, or I want sunlight or something else. Same thing for Indomie. Indomie is a brand name, but a lot of people are like, do you guys have Indomie? And you're like, okay, yes. And then you go, no, I don't want that. I want Dangote or Mimi or something. Then you realize, oh, the person is asking for noodles. So, sometimes it's unique at the beginning and then it becomes generic over time. However, there's a case rather that was, was like hot topic during the pandemic, and that is the booking.com case, where the court was like, even though booking is like a generic word, but the .com added to it made it distinctive. It had also acquired like a secondary meaning in the minds of consumers, and so we're giving it the go ahead to be registered as a trademark, because the US Patent and Trademark Office had rejected their registration, saying it was not distinctive enough, it was a generic word. And so there was so much anticipation for the Supreme Court judgment, and it was like the first oral case done in over, I think, almost 200 years. So you can imagine. Don't bite me, Sha. Anyways, I did a podcast on that last year where I talked about whether or not a generic word can be registered or not. So just have a look at it. The advantages of a generic word is that you must have acquired and met the distinctiveness requirements, which I said like at the beginning, it can be distinctive. It must also not cause confusion amongst consumers. The disadvantage is that it's considered not to be strong enough and it might lose its value over time, that kind of thing. Last but not the least is the descriptive mark. It tells your consumers what's the feature of your mark or your products and services, the characteristics, the quality of the product. However, if it has acquired like a secondary meaning, just like the generic mark, it can be protected as a trademark over a duration of time. That means you must have consistently used the mark. So for instance, you have Sharp for TV. Their slogan is Be Original. Holiday Inn is a resort and hotel reservation company. It also has like its own hotel. I know I've used their services sometime in 2015, early 2015, early 2015. Then the disadvantage is that it's not considered to be enough, which is not considered to be distinctive enough, which is really sad. I mean, I go through all that effort and I call my brand Sharp Be Original. Then someone's telling me it's not distinctive enough, but So in selecting a mark, you would need to have a discussion with your intellectual property lawyer, who will guide you on choosing a unique, strong, and distinctive mark. So the person will take you through these 5 types of mark: a distinctive mark, a suggestive mark, an arbitrary mark, a generic mark, and a fanciful mark. That's why you need an IP lawyer. In my tweet, I had also shared like a link to an article by Eric Pelty. He was on my podcast last year during the Christmas edition, and it's titled "Measuring Brand Strength with the Bold Brand Score Sheet." So that's like a very useful article you guys can check out. His Twitter handle is at TM for small biz. Great guy. So another thing you need to consider while doing a trademark is confirm the availability of the mark and also the domain name. Domain name is like something is like a name or a web address that can be affiliated to your brand. So www.jumia.com or rita.com, that sort of thing. Then write a letter to the trademark registrar to get like a preliminary advice on how distinctive your mark is, as according to Section 17 of the Trademark Act. So these are the things that if you talk to your IP lawyer or your trademark agent, they are supposed to tell you all of this, so you're properly guided and it doesn't turn out to be like you wasted your money. Function of a trademark. Now, other than it being distinctive, the mark must be linked to a source. It must be original, guarantee quality, and also perform the function of advertising while it's still in constant use. Now, trademark also act as a tool for maintaining goodwill and reputation, especially where a dispute arises. It also can prevent others, like a third party, from using and copying and imitating your mark. How to know? So when you see the sign, the R sign, means the mark is registered. When you see the TM behind anybody's name or logo, it means it's an unregistered mark. And if you see S, it means it's a service mark. Now, after identifying the types of mark, you can now look at the marks that are allowed to be registered under our Nigerian Trademark Act. So the type of marks allowed under the Nigerian Trademark Act are: 1, an associated trademark, and this is said to be a registered mark that allows an identical trademark in respect of any goods to be registered other than the proprietor. So it tries to guide against likelihood of confusion. I know that when you're suing for a trademark infringement, that's one of the requirements. You need to show that the marks in question is capable, is likely to cause confusion amongst your consumers. However, Section 27 sub 1 provides that the registrar may at any time register the trademark as an associated mark, sometimes provided by the same business with similar descriptions of goods, but will be treated as one mark. So if you want to register more than one mark as a subsidiary, it will now be considered to be one mark owned by one person, and to be treated as one mark, and not might not directly reduce any confusion among the public, especially when the consumers are not even aware that there are different marks. For instance, Pepsi, Co, and Pepsi. Do you even know? I only found that out while I was doing the research. So the advantages is that it helps the trademark registry to keep a clean and organized data. It also keeps it in check for a defensive registration. I'm going to talk about that later. Then Section 27 sub 2 gives the proprietor the option to request to register to request the registry to dissolve the association of the mark that is not valid and is not likely to cause any confusion or deception. I know that's another reason why your mark may be refused. The advantage is that it is also a good one if it doesn't affect the identity of the mark. Remember, a trademark is a source identifier. The mark is assignable and transmissible. Subsection 3 further provides that any decision of the registrar under Section 27 is subject to appeal at the Court of Appeal. At the Federal High Court. Oh my God, what is wrong with me? Apologies, guys, but that happens sometimes. And we already know that when it comes to IP related disputes, all disputes are filed at the Federal High Court. So if the registrar's decision is not fine by you, cannot appeal at the Federal High Court. Got it? Yeah, got it. Moving on. Now, the second type of mark allowed under the Act is a separate trademark. So under Section 24 sub 1, it provides that if you wish to enjoy the exclusive rights that comes with being a trademark owner, during your application, you have to state that it's for the whole mark or some part of the mark as a separate mark. So for instance, in the case of Apple Inc. against the Vincenzo and Giacomo Bato Ive brothers over the use of the name Steve Jobs in a stylized letter for clothing. So what happened was that these two brothers decided to register Steve Jobs with the letter J, half-beaten J, and the leave. And Apple Inc. sued them for using the name for a clothing line, and they lost the case. So sometimes if you have the vision of expanding, or yeah, expanding basically, you should consider doing more trademark registration in different classes, else someone else will do that before you, and then depending on the jurisdiction, the person will be given the right to own that mark. However, you must meet the requirements set in subsection 2 that provides that the mark in question must be an independent trademark in line with section 36 sub 2, where it says that the use of the whole registered trademark shall, for the purpose of the mark, be deemed to also be a use of any registered trademark, whether it's being a part or registered in the name of the same proprietor by virtue of section 24 of the Act, and it is also considered to be registered as an associated mark. See section 28 of the Act for that. I hope it made sense. The third example is a certification mark. Now, a certification mark is all about, setting standard. This is like our standard. You have to abide by it. That way, if consumers need to use this brand, they say, oh, okay, it has met the standard of whatever organization they are affiliated with. It also tells the consumers the origin, the material used, the mode of manufacture, the quality, and other characteristics. So it's more like when you see brands like Woolmark, which is already registered in like over 140 countries and has its own standard in like 65 countries. So it gives you an idea of how the quality of the mark might be, or say talking of a leather, and you're not allowed to use it. You're only allowed to use it if you meet the standard set out. So you have associations, you have to identify with them and find out what are the standards or regulations they have for a particular brand. Then you have defensive trademark, which is used to prevent trademark infringement. You may register that mark with no intention of actually using it. You just want to have a trademark registered in different classes. So sometimes when I see, especially the American applications, you see, let's say, like I know I saw the one for Kanye West last year, and he registering so many products in different classes, and I was like, whoa, that's a lot of money for the trademark lawyer. But then sometimes person is just doing it as a defense so that someone doesn't take advantage of the goodwill and reputation of that mark in question and decides to go and register it. And just like the Steve Jobs case, if Apple Inc. had thought about it, the director Steve Jobs as a defensive mark, but oh well, it happens. So examples are Nike, Facebook, that have registered marks in classes that they don't even have plans of using. So in the event of an infringement case, especially in a jurisdiction that applies the first to file principle, you may have an edge. Also in jurisdiction like the US and the UK, first to use. So if I start using the name before you, like that one's like I think it's like a disadvantage. So let me just say that as a disadvantage in a jurisdiction that it's advantage now. So in a jurisdiction where they apply the first to use principle, and maybe the likes of say Nike, they're not using, like they did not think of registering it as a defensive mark, but it's just like, okay, maybe in future, and then I start using Nike for something, I can be prevented from using that name. Other than the fact that it's a well-known mark, I can be prevented from using the name. So I now asked, I did another poll. Do you consider Katrina's mark Boss Lady to be defensive? 50% said yes. Ooh, why? And 33.3% said no. 16.7% said it's too generic. I don't think Boss Lady is a defensive mark, because going by definition, you're using it to prevent trademark infringement. So is she registering it so she can prevent T-Boss or any other person from using Boss Lady? I highly doubt that. And again, going by the definition, it says sometimes person might register the mark with no intention of using it. So if she doesn't really have an intention, then yes, I'll agree with the fact that it can be considered to be a defensive mark. But if she has intention of using it, then it doesn't fall under being a defensive mark or even considered, although the voting was like really low, but boss lady is not a defensive mark. So yeah, kudos to the no. I think the no's have it today. I keep saying that. Now, according to Section 3 of our Act, it says registering a trademark means that you get to use the mark only in Nigeria, since trademark and IP is territorial in nature. And you also have the exclusive right as the owner. So, can you now sue? You can now sue an infringer at the Federal High Court through your IP lawyer. You can also put up a trademark notice informing people or everyone that you are the bona fide owner of the mark, just like how Katrina did. She was like, "Boss Lady is officially trademarked under Amel Katrina Enterprise. Cheers, Boss Nation." Emoji, cling, hashtag Boss Lady trademark. Warning, now you all be careful how you mention my name. That's a pretty good notice. Then you have the Dr. Motola, where she just did simple. Motola is now trademarked. I don't know what that emoji is. Yeah. Then you also have Diola Sajer. She also did a trademark notice saying she had registered the design of her famous Komolu. Yeah. So, and I also did a tweet about that because I know something came up and I had to do that, where someone was like, "Oh, she can't register the industrial design or the trademark of that." And I had like, okay, I think I need to clear this up. I mean, we have fashion designers out there. They need to know the options they have, in protecting themselves and all that. So you guys can check that out. I also posted the link, and it was a 2019 tweet. So I mean, it's been a while. So I've also talked about the trademark register, but I've never stated the powers and function of the trademark register. So I'm going to do that now. Powers and functions of the trademark registrar. So section 1 sub 4 of the Trademark Act provides that the registrar shall have an official seal, which shall be officially and judicially noticed. So check your trademark certificate, whether there's a seal on it, to be sure that you actually have the trademark of your brand. Anyways, section 2 sub 1 to 2 provides that the registrar shall keep a register of the trademark registered, assigned, transmitted, the names and addresses of all the registered users. They also accept and refuse and give reasons for trademark refusal or a conditional appearance. See section 18 sub 2. They, according to section 20 sub 3, they also send a copy of every notice of opposition. Another function is that the trademark registrar issues trademark certificate according to section 22 sub 3. They can also remove a mark on the grounds of non-use. That means if you registered the mark, you now abandoned it, you now stopped using it, you're not using it again for a period of 5 years, your mark will be removed from the register. Section 63 also gives the registrar the power to publish a trademark journal. So those are like the functions and powers. Like, I just had to name like a few. It's a whole lot. And if you go through the Trademark Act and also the trademark regulation, you see the different functions and powers that the registrar has. So take note, guys. Then I did a final poll asking people. So in this clash now between the two ex-BB Naija, Big Brother Naija ex-housemate, that's T-Boss and Katrina, who is truly entitled to use the word boss, hashtag boss lady, and 66.7% voted for T-Boss, 16.7% voted for Katrina, and 16.7% said none of them. Really, guys? Come on. But I feel if T-Boss had done the needful, she probably would have owned it, but sorry. So yeah, on to the next IP series. Thank you guys for reading, for liking, for retweeting, for sharing, for subscribing to my podcast on Anchor and streaming via platforms like Spotify. I mean, I'm super excited that Spotify is in Nigeria right now. Google and Apple Podcasts, Radio Public, Overcast, Listen. Thank you guys so much for the love and support. I mean, I started this in May 2020, so I'm looking forward to my 1 year anniversary. I don't know what I'm going to do next, but yeah. So if you have any story or recent developments or cases you want me to talk about, you know what to do. Tag me, send it to my DM, send us an email to ipseries.info@gmail.com or leave me a message on Anchor and I'll listen to it and respond. So yeah, thank you and see you in the next episode. Cheers, guys.